Section 1512C2 overlaps with other obstruction statutes, but it does not render them superfluous. Section 1503, for example, which covers pending grand jury and judicial proceedings, and Section 1505, which covers pending administrative, and congressional proceedings, reach, quote, endeavors to influence, obstruct, or impede, unquote, the proceedings, a broader test for inchoate violations than Section 1512C2's, quote, attempt, unquote, standard, which requires a substantial step towards a completed offense. See United States v. Sampson, 898F-3T 287, 302, 2nd Circuit 2018. Efforts to witness tamper that rise to the level of an endeavor yet fall short of an attempt cannot be prosecuted under 1512. United States v. Leisure, 844F.2D 1347, 1366 to 1367, 8th Circuit Court, 1988, collecting cases recognizing the difference between the endeavor and attempt standards, and 18 U.S.C. 1519, which prohibits destruction of documents or records in contemplation of an investigation or proceeding. It does not require the nexus showing under Aguilar, which Section 1512C2 demands. See, e.g., United States v. Yielding, 657F 3D 688, 712, 8th Circuit, 2011. The requisite knowledge and intent under Section 1519 can be present even if the accused lacks knowledge that he is likely to succeed in obstructing the matter. United States v. Gray, 642F.3D 371, 376 to 377, 2nd Circuit, 2011. In enacting 1519, Congress rejected any requirement that the government provide a link or prove a link between a defendant's conduct and an imminent or pending official proceeding. The existence of even substantial overlap is not uncommon in criminal statutes. Loughran, 573 U.S. at 359 N-4. See Shaw, 137 S. Court at 458 to 469. Aguilar, 515 U.S. at 616, Scalia J. dissenting. The fact that there is now some overlap between 1503 and 1512 is no more intolerable than the fact that there is some overlap between the Omnibus Clause of 1503 and other provisions of 1503 itself. But given that Sections 1503, 1505, and 1519 each reach conduct that Section 1512C2 does not, the overlap provides no reason to give Section 1512C2 an artificially limited construction. See Shaw, 137, South Court at 469. The legislative history of number 3. The legislative history of Section 1512C2 does not justify narrowing its text. Given the straightforward statutory command in Section 1512C2, there is no reason to resort to legislative history. United States v. Gonzalez, 520 U.S. 1 and 6, 1997. In any event, the legislative history of Section 1512C2 is not a reason to impose extra-textual limitations on its reach. Congress enacted Section 1512C2 as part of the Sarbanes-Oxley Act of 2002, published L. number 107-204, Title 11, 1102, 116, Statute 807. The relevant section of the statute was entitled Tampering with a Record or Otherwise Impeding an Official Proceeding. 116, Statute 807, emphasis added. That title indicates that Congress intended the two clauses to have independent effect. Section 1512 was added as a floor amendment in the Senate and explained as closing a certain loophole with respect to document shredding. See 148 Congressional Record S6545, July 10, 2002, Senator Lott. ID at S6549-S6550, Senator Hatch. But those explanations do not limit the enacted text. See Pitstone Coal Group versus Sieben, 488 U.S. 105, 115, 1988. It is not the law that a statute can have no effects which are not explicitly mentioned in its legislative history. See also Encino Motor Cars, LLC versus Navarro, 138 S. Court, 1134, 1143, 2018. Even if Congress did not foresee all of the applications of the statute, that is no reason not to give the statutory text a fair reading. The floor statements thus cannot detract from the meaning of the enacted text. See Barnhart v. Sigmund Coal Company, 534 U.S. 438, 457, 2002. Floor statements from two senators cannot amend the clear and unambiguous language of a statute. We see no reason to give greater weight to the views of two senators than to the collective votes of both houses, which are memorialized in the unambiguous statutory text. That principle has particular force where one of the proponents of the amendment to Section 1512 introduced his remarks as only briefly elaborating on some of the specific provisions contained in this bill. 148 Congressional Record S6550, Senator Hatch. Indeed, the language Congress used in Section 1512 C2, prohibiting corruptly obstructing, influencing, or impeding any official proceeding, or attempting to do so, parallels a provision that Congress considered years earlier in a bill designed to strengthen protections against witness tampering and obstruction of justice. While the earlier provision is not a direct antecedent of Section 1512 C2, Congress's understanding of the broad scope of the earlier provision is instructive. Recognizing that the proper administration of justice may be impeded or thwarted by a variety of corrupt methods limited only by the imagination of the criminally inclined. S. Rep. number 532, 97th Congress, 2nd Session, 17 to 18, 1982. Congress considered a bill that would have amended Section 1512 by making it a crime, inter alia, when a person corruptly influences, obstructs, or impedes the enforcement and prosecution of federal law. Administration of a law under which an official proceeding is being or may be conducted, or the exercise of a federal legislative power of inquiry. ID at 17 through 19, quoting S. 2420. The Senate committee explained that the purpose of preventing an obstruction of or miscarriage of justice cannot be fully carried out by a simple enumeration of the commonly prosecuted obstruction offenses. There must also be protection against the rare type of conduct that is the product of the inventive criminal mind and which also thwarts justice. ID at 18. The report gave examples of conduct actually prosecuted under the current residual clause in 18 U.S.C. 1503, which would probably not be covered in this series of provisions without a residual clause. ID. One prominent example was a conspiracy to cover up the Watergate burglary and its aftermath by having the Central Intelligence Agency seek to interfere with an ongoing FBI investigation of the burglary. ID citing United States versus Haldeman, 559 F.2D 31, D.C. Circuit Court, 1976. The report therefore indicates a congressional awareness not only that residual clause language resembling Section 1512 C2 broadly covers a wide variety of obstructive conduct, but also that such language reaches the improper use of governmental processes to obstruct justice. Specifically, the Watergate cover-up orchestrated by White House officials, including the President himself. See Haldeman, 559 F.3D at 51, 86 to 87, 120 to 129, and 162.